Hello, everybody.
All right, thank you, Madam Monitor. And once again, to the plaintiffs, Mr. Stephen Stanley, if you could just turn on your camera for the court.
Hold on, I have to get the officer. He's coming right now.
All right.
Because I don't see you either. You're still there, right?
Yep, I'm
You
still
just
here.
turned on the camera, he said. There's no video thing.
No
Yep,
video?
if you could
The
just turn on.
officer's right here. Hold on 1 second. He said for you to turn on the camera. I didn't want to touch nothing.
Control shift.
Trying to get, they asked for the camera to be put on. Because I don't see them and they don't see me.
When you click on it, nothing happening.
I'm just gonna sign out and then sign back in.
You want me to tell them or? We're gonna sign out and sign back in, so give us 1 second.
There we go.
Okay.
That should work.
Do you have me now?
Yep, perfect. So we can
I
see.
don't see you though.
Yep, don't worry. The judge will be joining shortly.
Who do we have for a judge today?
That would be Judge Graff.
Thank you.
Good afternoon, everybody. The Talon Superior Court is now open and in session. The Honorable Judge Graff now presiding. Good afternoon, Your Honor.
Good afternoon. Good afternoon, everybody. We're here on the matter of Stephen Stanley versus Harold Stanley. The docket number is 2450-18168. Can I have the parties identify themselves for the record, please, starting with Stephen Stanley?
Yes, for the petitioner, Mr. Stephen Keith Stanley.
And do we have,
I believe it would be Kevin.
is Kevin on?
I was told that Mr. Kevin Stanley would be joining us today, although I do not see him
He's
logged
been
on.
there since 1 o'clock.
Okay, hold on, Mr. Stanley. Let's just see.
So
That's
let me
okay.
reach the clerk's office to find out how this is going. I'll be right back, Your Honor.
Okay. I'm just going to mute myself until we get him on, okay?
Thank you.
You're welcome.
Hey, what's up? How are you, Your Honor?
Hi,
What's going
Mr. Stanley. All right, so it looks like we have Mr. Kevin Stanley with us. Mr. Stanley, can you hear me okay?
Yes, ma'am, I can. Thank you very
Okay,
much
great.
for everything
Thank
that
you.
you're doing. Yep.
Thank you. Thank you for joining us. All right, we are here on entry number 142, which is the motion to waive a filing fee, which Mr. Stephen Stanley filed, which was denied by the court. And Mr. Stephen Stanley, you were looking for a waiver of a fee for a jury trial. So did you want to be heard on that, sir?
I do, Your Honor, yes.
All right, you may proceed.
All right, so under Connecticut General Statute 52-259 lowercase b, clearly says anybody that's incarcerated or collects unemployment is indigent under the eyes of the court. In the State of Connecticut State Registry and Manual amendment, the Constitution of the United States, the 7th Amendment, and it states, and I will quote, in suits as common law, comma, where the value of the contrary shall exceed $20, comma, the right of a jury trial shall be preserved, comma, and no fact tried by a jury, comma, shall be otherwise re-examined in any court of the United States, comma, than according to the rules of the common law. So therefore, again, Kevin Stanley was a defendant at the de novo trial. The problem is that we had a trial in December with Judge Gordon. Well, my brother's attorney father died that day. So all my subpoenaed witnesses, the court's subpoenaed witness that came voluntarily, everybody, even Kevin, everybody was there that day. Well, because of the illness and his father's death, there was no objection to anybody to prolong it where it went till February. Well, February, now we have David Sheridan, Judge David Sheridan, and now he's failing to comply to the granted court order of a jury trial, which was already number entry on the other docket, number 127 and 129 of closed pleadings. There was no objection, nor was there any filing of an affidavit from my brother's attorney. So therefore, again, and under that docket number, he abandoned the petition because he didn't object to my jury trial that was already entered, 127, or actually the fee waiver was 127, and the jury trial was 129. And if you like, I could give you that docket number. Would you like that?
Yeah, yes, that would be great. Thank
Okay,
you.
so that entry number of that docket was TTD-CB22-501-6509-S. And that was number 127 was the case, well, you'll see in the case for lookup. 127 was the trial, and 127 was the fee waiver, and 129 was the jury trial. And I believe, 127 was the jury trial, and then 129 was the claim for a jury trial, and the closed pleadings was entered, but it was never ruled upon. There was two of them, and that one prior. So therefore, again, this case originated for a jury trial, all the subpoenas, everybody that took place. Well, here we are today, because it never took place with Kevin being there, no jury, no nothing took place, and the defendant, my brother's attorney, failed to object to any of these filings. So therefore, again, under Connecticut Supreme Court rules, federal laws and Supreme Court cases apply to state court cases, and the statutes do not apply. So therefore, again, he abandoned the petition. By Kevin not being there at that trial originated. So therefore, again, we're back to my 52-259 lowercase b that clearly waives, and you've said on other things that the court don't waive certain things. I've had, all the way back from the trial courts, the courts have paid for my practice book. They've ordered a place in Enfield to provide the practice book. They've waived the fees for statute books. Judge, I forget the name, the last trial just in Rockville, they actually waived the fees for the statute book, gave me a brand new statute book, every kind of law book, and even Judge Newsom in 2018 waived all legal copies, postage, everything, and I can even give you that docket number if need be. So therefore, again, a fee waiver is used for many things in the court's procedures, and my things have been granted. Even one of the worst judges I've ever ran across, Judge Quack, he granted the practice book. So, I mean, if I'm pronouncing that right, I believe that's his name. Not trying to be smart. And again, judges across the board have granted several things. So therefore, again, under the registry and under Article 7, I am entitled to a jury trial for anything over $20. Kevin Stanley was never there. It never took place of a jury trial. I withdrew that entry prior to that hearing, and on the record, and I can give you the transcript. You were going to say something?
No, go ahead.
Okay, so anyways, I withdrew that on the record, and on that hearing date, again, my brother's attorney failed to file a counter brief to pick up that docket number so he could reclaim it to reopen the file. So therefore, again, it was never a jury trial. Matt Grimes filed an objection already. I filed an objection. I don't know what entry you have. My motion is dated 6/6, and it's a motion opposing and object to the defendant's May 27, 2025 objection to the last parties of record of a jury trial. And clearly, I stated really clearly that the court granted his summary judgment. So therefore, again, if we go down to my legal arguments, I stated he's not a party of this record no more, nor does his motion have any stand, so it would be considered moot. So therefore, again, it is me versus Kevin Stanley where we can't come to an agreement. I've already explained to you before, when our last hearing, that we need we could pick jury date on the same day, and we can have this jury on same day. Attorney Danforth, he was coming to court voluntarily for Judge Gordon before, and I've reached out to him again through my people, and he's willing to come again. The court just has to pick up the phone and just request for him, and he said he would give his expert testimony. Kevin, on the other side of being defendant, had no objection to Attorney Danforth. I'm not even going to subpoena anybody. I even have the Secretary of the State of January 15th of this year has recertified that handwritten will to make it authenticated. Therefore, again, it is January 15th. It is bound, sealed, and riveted together that they authenticated that handwritten will. That is the valid will. I have a federal case law that I've submitted in exhibits before. Aretha Franklin, we're all aware of her, this artist.
Yes.
That question was for you, Your Honor. So anyways, they found a handwritten will in her couch cushions, and I've submitted the documents. I don't know if you have it or not, but a handwritten will was found 2 years after the fact, and they honored that handwritten will that they found in a couch cushion, under a couch cushion, in a jury trial in a federal court of law. I have the whole case that awarded that a handwritten will is valid. So therefore, again, Kevin Stanley had forfeited any rights to be in anything to do with his estate in 2008. He forfeited it all to me in 2008. So therefore, again, he could be a certified witness in the 2010 new handwritten will. And even my mother says that she vacates that old will, and this is the new will, what her last dying wishes wanted. So therefore, again, I'm asking for a jury trial. I'm not trying to be belligerent with the court. I figured we could knock this out in one day, and we're having one expert witness come in, Attorney Danforth, that was coming in voluntarily for the court. With your permission, again, all you'd have to do is pick up the phone, and he would appear again on courtesy for the court. So therefore, again, besides the jury trial and my statute that I listed, I'm entitled to it. Again, as well, the state's registry guarantees my right for a jury trial. You check my fee waiver off in the area where you didn't list nothing, and we go back to other fee waivers. I can give you the entry numbers where you said they weren't ripe at the time and this and that. We're moving up now where we need this jury trial between me and Kevin because we can't come to an agreement. We could knock this out in a day, and I'm sure we could probably get a ruling ASAP. And again, so I'm asking the court to waive the fees for the jury trial, which I'm entitled to. As you know, I'm sentenced to 30 years and I have no money. So therefore, again, it is very crucial for myself to have this jury trial so we can get to the bottom of this, and it would be done, I'm assuming, within a day.
The issue, Mr. Stanley, is that General Statute Section 45A-98A,
Yep.
parenthesis B, states that if a party fails to file an affidavit of intent to claim a jury trial prior to the initial hearing in the probate court on the merits, or having filed such an affidavit.
And can I stop you for a moment?
Yes.
Okay, at the probate court on 2 hearings, and I have exhibits ready to go to show you. On 2 hearings, they had me on the phone. They disconnected me twice. So therefore, again, they abandoned my right for a jury trial. I filed a habeas to be habeas in from the beginning. The Judge Gardner in probate court declined. And you cannot refer, just like I told Judge David Sheridan, you cannot refer to anything of the probate court because we had a de novo hearing which vacates that probate court. So anything that went wrong with that Judge David Sheridan kept referring to, or anybody else, is irrelevant and moot. In Connecticut General Statute, I got a whole book of endless case laws, federal and the Supreme Court cases, that when a de novo hearing is entered, all other existing trials are moot and they're basically irrelevant to the fact. And anybody that cites anything to that knows better, and that it can't be used against you in a court of law. So therefore, again, with Connecticut General Statute, because of my indigency, therefore, again, we never had a jury trial. You'll see my entries. I've never abandoned the petition. If anything, the defendant abandoned it when he didn't object on the record, nor did he file any motions. There's nothing in the filings of all the filings of the of that docket number that I gave you where he was opposed to objection. So we must refer to the trial court of the de novo, where there was never no objection to my jury trial. And on the record, I withdrew it that day. So that stopped everything. Whether the ruling that Judge David Sheridan filed or not, a person is entitled to a jury trial. And I got Connecticut Supreme Court cases that says that's an automatic reversal as soon as he denied me my rights for a jury trial. So therefore, again, the statute that you're citing, by going back to the practice book, it does not apply to this case at hand, Your Honor.
Okay, but you understand which statute I'm referring to? Just
I am.
Okay, I just want to make sure you understand the basis of why I denied the fee waiver was because there's no indication that in the probate court proceeding you filed the proper paperwork or affidavit with showing that you had the intent to claim a jury trial of the probate court's decision. And under that statute, if you don't do that, at the probate court level, you can't have a jury trial on a probate court appeal.
Okay,
Which-
but again, when the hearing we had, the de novo hearing is a de novo hearing. It was not an appeal. It was a hearing. You keep referring to the probate court. The Connecticut General Statute of the Supreme Court of Connecticut confirms that a de novo hearing, it says it's, I can read the law book even, and it says it stopped all proceedings in the probate court, and anything from the probate court is irrelevant and moot. So yourself, I keep citing it. That's like me right now citing the statute book where I filed this case in Hartford. Matt Grimes, you gave him summary judgment. I tried to say you didn't have jurisdiction because it was transferred improperly to Rockville. You didn't abide by your own statute book that says it is the option of the petitioner, mine. So it was illegally transferred to your jurisdiction. I feel, now we're citing the statute, not a practice book, we're citing the statute. The law says it was my option where it would be filed. They have a hearing in Hartford where it should have been. You jumped over jurisdiction. I don't feel you had it. You gave him summary judgment, and I explained to you on the record that says when there's any evidence or any exhibits in dispute, and if I don't consent, summary judgment is off the chain and it's gone. And the law book says, again, you keep referring to the probate court. We cannot refer to the probate court, and anything you're citing from the practice book doesn't apply because we did not have an appeal. We had a de novo hearing, and I can read in the law dictionary, Black Law Dictionary, it says anything of a de novo hearing, it has irrelevant of anything at the probate court, and that has nothing to do, and it's moot. And if you like, I'd pull it out if you want me to read it on the record. I think you know what the Black Law Dictionary says about the probate court and de novo hearing, that everything from the probate court is irrelevant, Your Honor. So therefore, again, I'm not judging you, but I believe that you're totally wrong. In that hearing that we had, where on me on the record, I withdrew it right then and there because you wouldn't accept my motion. So therefore, again, that's an automatic reversal. And I had my entries for a jury trial as well as there was no objection. So therefore, again, if anybody abandoned the petition, it was the defendant, because he didn't even file anything for a counter brief objection, nor did he file anything to reopen that docket number. So again, I do believe I'm entitled to a jury trial on my indigent status. I'm sorry.
That's okay. I didn't mean to cut you off. I understand your position. Is there anything that you wanted to add, Mr. Stephen Stanley, before we adjourn?
No, it's just that, Your Honor, that I feel that you're hindering my case and you're blocking me. I have till August 11th for the appellate court, and this would be evidence right here to support everything that would vacate that. And again, endlessly, the defendant, I'm going to give you a scenario. The defendant asked for 7 extensions in the appellate court. In 15 months, they granted everyone. I filed 1 extension for my counter brief asking for an extension for 120 days. They gave me 5 weeks and they said, this is your only extension ever. You talk about being biased. So again, my only resource is here today in this court where we even have housekeeping matters of endless motions that are filed that even ask you about a bill of particular that nothing's been ruled on all these things. Any housekeeping matters, the law book even says that we're supposed to, all issues come to a halt till we address the housekeeping matters, where we have these endless affidavits supporting exhibits and everything that should have been addressed long before this hearing, and you went ahead and granted summary judgment. Now you're telling me that you're denying me my civil right for my fee waiver. We're only hearing an indigent status, Your Honor. So that fee waiver that you denied, you didn't check anything else saying denied for frivolous, anything that you checked the box where it was blank. So the only thing that is checked for that we're here today is Mr. Stephen Stanley indigent. In the eyes of Connecticut, I am. So therefore, again, we need to proceed forward to this jury trial.
All right. Mr. Kevin Stanley, is there anything that you wanted to add?
I just, how's he doing for an attorney, my brother? How's he doing is he doing all right? I think he's doing good.
All right.
Can I ask you a question if I can?
Sure. What did you want to ask him?
Do you have any objections to anything I said today about you wanting a jury trial?
No, me, no.
Okay. Do you want a jury trial for the first time because you were not heard at the probate court, nor were you heard at the de novo hearing?
Yes, of course. Of course I do.
Are you wishing a jury trial?
Yes.
Thank you. So because we both disagree, you're asking for a jury trial as well as I am, correct?
Yes.
Thank you, Your Honor, for bearing with
All
me.
right. Okay. All right. I understand both your positions and I understand your argument, Mr. Stephen Stanley. So I will take another look at it and issue a ruling. Is there anything else that you wanted to tell me today?
I would just like you to go back to that other document number I gave you and see the entries where there was, if anything, if there's any abandonment, I filed my jury trial that was marked off, by the way, for the court, marked off. It wasn't rejected, it was marked off. So therefore, again, I had closed pleadings entered. I even had the jury claimed. Everything was entered, Your Honor. So it's proper to meet the format as you're stating in the probate court, but the de novo is the probate court and everything was all in order and there's no
She'll
objection.
do her
to the
job,
defendant.
man.
There was no objection to the defendant. So therefore, again, if anything, he abandoned it because for one, he didn't object to me asking for a jury trial at the de novo. Everything that you say, I agree with you 100% that I need to request for these things ahead of time. They were all entered because the de novo hearing is taking the place of the probate court. Like we all agree, the probate court didn't happen. So everything, the entry numbers, Your Honor, 127, 129, if you look at all the entries, you'll see everything is properly filed and there's not one objection. So therefore, again, if anything, it's abandoned by the defendant because he didn't object to me asking for the jury trial, nor did he even file a recounter to reopen that docket number for anything about that case when I withdrew on the record. So I believe for everything I'm telling you, and if you do your due diligence, you will see that the de novo hearing, everything was entered exactly what you're saying that would take place of the probate court, Your Honor. So I'm asking you to expedite this so that we can get this resolved in the next couple of weeks so that I will be on board at the probate court where we can have the Secretary of the State's statement that Kevin has the confirmed documents that it's re-authenticated at the Secretary of State, signed by the Secretary of State, that we all abide by, and he has it in his possession. If you need to see that, I told him don't pull no rivets out or nothing. Leave it the way it is because that is a authenticated document. So therefore, again, that Secretary of State speaks for itself about this new will is the valid will. So therefore, again, I'd like you to take everything in, under advisement, and if you need to, I'm sure Kevin Stanley can produce that for you to witness that brand new authenticated, that verified this new will is the law of the land.
Thank you,
Okay,
Your Honor.
You're asking, there's something that you said that I may have misheard. You're asking for a jury trial in the Superior Court, not in the probate court, correct?
That is correct, because again,
Okay.
we're back to this is not an appeal. I'm asking for a jury trial in your court of law, where basically, I'm assuming that we could knock this out in one day. I don't see a problem with picking the juries. I've even had my last trial in the other court, and we knocked out a criminal jury trial, I think, start to finish within 7 days. So basically, I think we could pick the juries within a day. We could probably even have the trial the same day. So it's not a burden of the court. The point is that I've asked for this for quite some time, and I think that this needs to be expedited immediately, where we can just get this on the record, make this happen, and put this case to bed once and for all. You got to understand something. That house and land, my brother Kevin sitting right there, he took 150 grand cash out of his account, built a house and a garage on that property, and my brother and his attorney had him evicted from the property. So let's just say hypothetically the old will is still valid. Well, the property is between 5 siblings, even under the old will. So how is he kicking my brother off the property that was the only one paying the taxes? So now no taxes are being paid because my oldest brother's trying to get the state to come on board, because when you're not paying the town taxes, now they're going to try to expedite everything. Kevin was paying the taxes right up to date since my mother's been dead because he lived there. He has a house built on this land. This is absurd. And I can't believe that this court is even stalling for any moment where we can just put this to bed and we can all move on with our lives.
Okay. All right. Like I said, I'll take another look at it and I'll issue a ruling, okay?
I thank you.
Thank you very much, Your Honor.
All right.
Thank you very
Have
much.
a good rest of your day.
Stephen,
Thank you.
Thank you, Stephen.
We'll
Yep.
stand in
Stephen,
adjournment. Thank
you're
you.
on. Yep, thank you
Thank
very
you,
much, Your Honor. Bye-bye. See you, Stephen. Hey.
I love you all so much. Be safe. Be well, sleep sweet, and much love.